Yeah, we can see. All right. What is that? I know, right? You put it on speaker. All right. Thank you. You have your microphone, Judge? No, I don't need it. Miss McDaniel, can you hear me?
Yes, ma'am, I can.
Making sure you're recording. Let me do that now. Where is the recording button? Record. Okay, now we are recording. Thank you. He's gonna adjust. And as people enter, can you let them in the room? They're right there. Okay, so we're going to go ahead and get started. Thank you all for being here for our end of the year lunch and learn. We intentionally didn't have one since, I believe, because I wanted to allow time for a lot of things I needed to discuss to happen. And then when people, you know, as more things were happening, we were making changes to our policies and procedures. So I just felt it was necessary now at the end of the year, going into the new year, to set expectations again, okay? Hello to everyone who is visiting us online. So our court reporter, Joey, who you can see her, she's sitting back there. Joey, well, all of my staff, we took notes to talk about some of the things that are not necessarily pet peeves, but just things so you can keep in mind. And excuse if I have, you know, my speech is slurred because I have on these braces, okay? So for the court reporter, make sure that you are sending your exhibits the day before. Send your exhibits the day before your hearing. It makes it easier for her. And not only should they be sent before a day before, they should also be sent electronically only. No paper exhibits at all. No paper, no big binders, not coming in with sheets of paper, nothing like that. Send everything digital. It makes it easier on the court reporter, especially when she has to upload these things to the Court of Appeals, okay? And if you have any questions, just make sure you jot them down, but then you also can ask in the chat.
For Judge Lee exhibits, email the exhibits directly to Judge Lee, but you can CC me the same way that you CC me with Joey's, just in case we're not here, it's always a backup.
Yes, always CC the court coordinator. In regards to Destiny, that's our court coordinator. Prove ups. You will always see Destiny on the prove up docket as well as the dismissal docket. Destiny.McGinnis@DallasCounty.org. DESTINI.MCINNIS@DallasCounty.org. You always want to send her your emails. That's my direct contact right there, okay? But in addition to sending Joy the emails, make sure you also copy Destiny on the email as well. Technology happens. Destiny doesn't always get the email. Joey may not always get the email. So as long as both of them are on there, at least one of them will get it. Or your prove-ups. One thing that we keep seeing constant is people want to get on the prove-up docket for defaults. Before you can get a setting on a default, all of your documents have to be on the computer. So if you're doing a divorce, you need the decree, the military affidavit, as well as the certificate of last known address, income withholding orders. Same thing with the suits with parent affecting the parent-child suits affecting the parent-child relationship, income withholding order, any exhibits that you need to attach to that, make sure that they are already on the computer. I read everything prior to hearings. Default dockets take place in front of Judge Lee now. I used to do them, but now Judge Lee does them. And I go through her docket, and if you're not ready, I remove it because it slows her down. And it slowed me down when I was doing it. So everything has to be on the computer. For any reason you happen to get on that docket before your documents are on the computer, I will remove you. So if you don't see your hearing scheduled anymore, that's the reason why. Also, included in your orders, this is very important on defaults. You have to make sure that if you're asking for sole managing conservatorship, you have to give testimony to support that. But even though it's the default, by law, I cannot grant a sole managing conservatorship without some sort of finding of significant impairment, best interest of the child. It's going to automatically default to the presumption of joint managing conservators, okay? The dismissal date, as well as the default or proof of date, Destiny will also be on those calls as well. Make sure that if you need a reset, you notify her 3 days ahead of time. The same day we've been working with you all to get it done within the same day or the day before, but that's very inconvenient. And considering those Zooms sometimes have at least 50 to 75 people on them, it's just very helpful if you do it at least 3 days in advance. This is important too. If your case has been inactive for 4 months, you haven't done anything on it, no filings, no court appearances, you must log on to Zoom on your dismissal date, right? Email communications. Do not include the court on your email communications when you and opposing counsel are arguing back and forth. That is extremely unprofessional and it bogs down the emails. So please don't do that. If you have a question for the court, you need clarification from the court, you need dates, anything like that that comes specifically from the court, that's all the communication that the court should be included on. And also, I just want to point out too, because we've noticed this has been going on too, watch what you write in those emails, because the people that you're sending it to is not the only one who's reading them. Every now and then, if it gets pretty bad, I'll have to step in. Okay, so just make sure you all are being very respectful and mindful of what you're writing in these emails. I already mentioned that all default dockets will be handled by Judge Lee. Default and dismissals only take place on Zoom. Nothing is in person. It's only on Zoom with Judge Lee's Zoom code. And make sure that you all are reading the policies and procedures. We update those at least every 3 months or so. As we see changes are necessary, we just made an addition about certificates of conference. One thing I have noticed is that people will come to court and they will settle in court. This is the first time that they've talked. The ideas that I have about family law, I do believe that it is possible for most people to work things out. If not everything, most things, right? But if you all are not affording each other the opportunity to do that, you're coming in court and you're settling in court, that could have been a spot for somebody else who really needed to have a hearing. So certificate of conferences, they are absolutely required. And on the policies and procedures on the website, it explains what that certificate of conference should include. Now, time limits. People have, that I've gotten a lot of pushback on time limits because I set time limits on hearings. But like I said, when I first opened up, I read everything prior. I literally go from the original petition file all the way through the summary of requested relief if one is on file already. I read everything. So I've taken a look at each one of these cases. And from practicing family law, from watching different attorneys, from sitting in different judges' hearings as a practicing attorney, you don't need 3 hours to try a case that only involves child support. So I'm really taking a look at what the issues are in these cases, especially on your pretrial order. If the court does not believe that all of that time is necessary, I will reduce the time, because I am confident that the competent lawyers can get it done. And I know you can get it done. Some of the things that I have been recommending for attorneys to do, as well as people that represent themselves, if you all can stipulate, that would save you a lot of time. Stipulate to your exhibits ahead of time. Exchange your exhibits ahead of time. Speak about the issue. What minor issues can you work out? So if you come to court and you have 5 issues, but then you realize the 3 of those issues are very minor and they can be worked out, work those out. It saves time. And from what I've seen, you all have gotten it done. You've gotten it done. And in most cases, or some cases, depending on what it is that, you told your client about me or the outcome of the case based on the law, it's working, right? If I believe that more time is needed, I will grant it. And just so we're clear, there's nothing in the law that requires me to give a certain amount of time on a certain type of case. Nothing requires me to give more time just because it's requested. Nothing is required of that of me. So if I believe that I need to hear a little bit more testimony on something, or something was not completely flushed out, I will address it usually at the end and ask your clients directly, or ask you directly for clarification for something, okay? If you run out of time, that's it. When you hear the timer go off, if you're in the middle of your question, I will allow you to finish that question, right? Or if your witness is on the witness stand and they're in the middle of their answer, I will allow them to complete their sentence. And I do that because of completion purposes for the record. But when your time is up, your time is up. Something else I think is going to be very beneficial, what the Associate Judge Jean Lee and I are working on, is an exhibit summary template. So the stipulation that I mentioned about the exhibit, instead of you all saying, okay, yes, I agree to this one, I agree to that one, we're actually going to create a template and put it on the court's website. So you will have it there to be a checkbox. That way, before you get to your trial, I already am aware of what it is that you all agree to. And we're going to incorporate that into the pretrial order. So you will submit it like you submit, any supplemental discovery, whatever the case may be. It just makes it easier. Some different things that we have moving forward that I want to do in the new year. Obviously, we're going to continue our lunch and learn sessions. Instead of doing them monthly, we're going to do them every 3 months. It's just easier. And I believe that the more information we have, because I understand scheduling and everything like that, we'll be able to cover a lot within those 3 months. Well, from what happened 3 months prior. We're also going to have a provider's day. I noticed from just being here for ad items, for CPS cases, whatever the case may be, we do not have a huge list of resource providers for mental health or child therapists. We tend to kind of use the same ones, but I know there are a lot of more resources that we have not tapped into. So I am going to reach out to the community, open it up to the public, anyone who is a licensed child therapist, licensed counselor, mental health provider, because as you know, we see a lot of different people with different, various mental health issues. This way, all of their needs are covered. Now, I'm not saying that we're going to have one person for every single type of issue. I don't think that's realistic, but I do believe that in order to have a better view of what people are dealing with when they come before me, I have to have different therapists with different points of view. I don't want it to be a cookie cutter situation where I am appointing the same people over and over again, and I'm reading some of the same conclusions. I don't think that's beneficial, especially with the community we serve. Everybody cannot have a 50-50 schedule. Everybody does not need to be on this particular medication, or every child does not have to go to behavior therapy. They may need play therapy, or they may need speech therapy, but if we don't explore that, we won't ever know. So I will be doing that sometime in the spring of next year. I also ask that if you have Beanie Babies, or you have access to Beanie Babies, or you come across Beanie Babies, please donate those to the court. We love Beanie Babies in the 255. When kids are adopted, that's one thing we give them to kind of commemorate the day. So if you would be so kind to donate Beanie Babies, that would be excellent. One of the law firms donated 4 headphones as well as 4 tablets to the court. When I was in, I believe it was in judge school, or it may have been a subsequent conference. I think it was the Family Law Justice Conference. One of the questions came up about allowing children to be in the courtroom. Well, as you all know, a child just doesn't come in and get on the witness stand like that, right? But I do realize that there are parents that cannot take off work, and when their kids are sick and everything like that. So it may be situations where kids actually come to court. So the law firm did donate those headphones as well as those tablets to the court. So if in an event of an emergency situation, or your client just cannot, drop the child off with a sitter or anything like that, or someone is representing themselves, they can't get a sitter, they are allowed to have their child sit in the jury box. They will get a set of headphones as well as a tablet to isolate any of the testimony or whatnot that they hear. The reason they will sit in the jury box because they will be monitored by their own parents. It's a security issue to have them in the back, just by nature of this being a courthouse, right? So they can sit here and their parents can watch them. And at the conclusion of the hearing, then they'll just go out with whatever parent they're supposed to at the end of the hearing. Child interviews. I perform child interviews in my chambers or here in the courtroom. It just really depends on the age and mental capacity of the child. Not all children like to be, in closed spaces, and I realize that. And I want them to feel comfortable because I want them to be honest. So if you get to final trial and it's a situation where you request a child interview, I will perform that. If you do it before your case gets to me, if it's at the temporary orders level or anything like that, it'll be heard by Judge Lee, unless you specifically request family court services to perform the child interview, right? Something else that has been an issue, and it has made me think about some things that I could do to provide a resource. Enforcement. They're very, very technical, right? You have to know how to draft a motion for enforcement. There has been less than 1% of people come in here, and I'm not talking about the people that represent themselves, because they really don't probably understand the law in general, but attorneys is less than 1% that are actually able to successfully have an enforcement hearing. And it's troubling because your clients are expecting that from you. And when they're hiring you and coming in here to me, they're expecting me to fix whatever the issue is. Well, I can't hold people in contempt if the motion is defective. I can't award attorney's fees if the motion is defective. I can't award attorney's fees if it's not being proved up. So I'm in the process of trying to figure out, and I'll be speaking a lot to the family bar, the family section, to see what can be done, if anything, in terms of maybe an enforcement boot camp or an enforcement session or something, where you all could probably get a little bit more assistance with that. Because I don't want to make it seem like I care or don't care one way or the other if people are upset with me. But in explaining to people, what I found as a challenge is in explaining what the law says about why I couldn't grant their relief, it throws the attorney under the bus. And I'm trying to keep from doing that because I don't want to embarrass any attorney in front of their client. It's not an easy task. Drafting a motion for enforcement is not easy. Defending a motion for enforcement is not easy, right? Because you have that question of, do I put my client on the witness stand or not? Bringing your motion for enforcement is not easy because there's so many technical things that go into that. So because it's not easy, I at least want to make sure that I do my part to the bar to see if there's anything that can be beneficial for you. I know we have different, seminars about enforcement. You learn about enforcement at advanced, but there's a disconnect somewhere. And I was really good at enforcement when I practiced law, and I memorized almost like a checklist. So I definitely have to make sure I'm allowed to, at least teach that to you all before presenting it. But I would love to help in that area because ultimately you want to see people follow court orders. I don't want it to be a situation, and I don't know across the 7 courts how much of this is problematic for them, but I don't want it to be a situation where people feel like they can just violate court orders because they know, they're catching on that they didn't do something right. The other side can do something right because it will start happening. And I don't believe that that's fair to anyone, right? Because you don't want people just going around violating the court orders. Could you see if there are any, a chat? Okay, nothing there. Okay. So that's my TED Talk. Do you ladies have any questions?
I did have one. So whenever we send the exhibits, do you want us to always copy the other side as well? Or I know you talked about exchanging everything, so I'm assuming the answer is yes on that. Okay.
Yes, yes, yes. Joey?
Yes.
Yeah, she'll repeat it.
Whenever we're sending you the exhibits, it was just verifying that we do copy the opposing party, attorney, whoever it is, whenever we're sending it to you in testimony.
Yes, and thank you for asking that question because often they get left off. You always have to copy everyone who is a party to the case, including the AG. I want to make sure I touch on that too. They're often left off. If a case involves child support, or if it involves and/or medical support where the child is receiving governmental assistance, the Attorney General is a necessary party. This is also important too, because I think a lot of the reason they're being left off is because your clients aren't applying for the service. If they apply for child support, that automatically triggers the Attorney General to intervene in the case. You don't want to get to the end of the case and we're going to final trial and you haven't even had your client apply for services. That kind of defeats the purpose. And it's really frustrating for the parties because you don't want it to be a situation where your client who has to pay child support ends up in arrears behind it. And you also don't want it to be a situation where the client that's supposed to be receiving the child support goes without. Make sure you have your client send information to apply for services. Then after they are intervening in the suit, always copy them on everything. Always send them an order, your final order, as well as your income withholding order. It makes it so much easier. And I won't even sign a final order that has child support without an income withholding order. And the reason that I do that is not to be punitive to anyone, but I'm trying to think about all parties that are involved. I don't want the Attorney General to have to come back into court and get something from me that they could have easily gotten from the attorneys when the case closed.
Sorry, I have lots of
You
questions.
okay?
So the policies and procedures, does that also outline what the preferred format is for the exhibits? So PDFs, JPEGs, in one document and several documents broken all down, the types of videos, all of that?
You know what? Thank you, because it does not. The only thing that we said is make sure that you send it in an email because we've been having problems. The county doesn't allow, like, you know how you send those links? The county doesn't always allow those links. So if you do send a link, I think OneDrive is the one that will, be okay to download. It's the other ones when you send those links, they don't really work. But we can do that and express to you specifically PDF, JPEG, and I'll even go as far as to make sure that I explain the jump drive. Because if you have a video, whatever, if you have a 2-minute video, if you're not going to use all 2 minutes, clip it, have on the jump drive what you're going to use, the whole 2 minutes, but then have the specific portion that you're going to play in court. If it's 20 seconds long, do a separate one where it's that portion of it. Oh yeah, it's one in there. Next question.
That's a, I'm trying to figure out, because there are videos that the court reporters get, and I would like,
We're in the Q&A portion, just in case anyone wants to send a question through the chat.
the way you send the email, it's the way you send the video, it's MP3 files. Court of Appeals doesn't accept those MP3 files. So I've always had a question with, I've got to transform the MP3 files into, I forget the name of it, but I will look for it real quick. And but I've always thought, well, then I'm altering the exhibit. Because if I'm changing it from MP3 to another format, then that's altering the exhibit, but the Court of Appeals won't take MP3 formats, and there's really, I'm stuck in the middle. So if I can get the exhibit from the attorney, and a lot of times I'll do that, I'll tell the attorney, hey, you gave me an MP3 file, I need it to be, but then how do I know they're not adding to the exhibit that was admitted? You know what I mean? There's a hole in the process that I'm not sure we've figured out, and the Court of Appeals frankly hasn't figured out a way either. I know Donna just did a Court of Appeals, and it was 20 volumes because of the length of the videos. And she couldn't figure it out, and she literally just had to take the Court of Appeals a USB drive. But they don't always accept those. So that's just, yeah. That's a question that I have.
So whatever format that you're going to send it in, just what I would recommend that you do is before you actually send it to the court reporter, you come to the courthouse and test it. Bring her a USB, whatever it is you're going to use, and see if it even works. Because then ahead of time, you know whether or not that MP3 can be used in court.
The MP3s can be played in court.
Well, that's not what I mean. I mean Court of Appeals, when you have to upload it. So if you can try a different version on your video, a different format, that will be helpful. Yeah. Do you have any questions? Okay.
Yeah.
Okay. Any feedback?
Very helpful.
Okay.
Yeah. It's a good overview.
Okay. Well, any feedback in terms of this year, what we can work on, something you would like to see us include in our policies and procedures?
I did have one more question. The sworn affidavits for prove-up, SAPSers and modifications, yes or no?
Yes.
Okay.
You want to
So you
do
want those for all of them?
all of them?
Okay.
Yeah. Yeah. I don't want to specify and say this one and not that one. Just do it for all of them.
Okay.
Oh, and that's something else. When you're doing those defaults, your statement of evidence. Make sure you submit the statement of evidence because I actually have to sign off on that. Oh, thank you.
I haven't had very many cases in your court this year.
Okay, that happens. That happens. It's on that big wheel and cycle and stuff, but we'll see you more often. Like I said, we're here to help, and however, we definitely want to be efficient. So that's what my court is striving to do, be more efficient, provide the resources, definitely not overwork ourselves because we already have a lot that we have to do. But some of the old ways of doing things, I'm just seeing that they can be tweaked a little bit. They can be a little bit better. It makes it easier for you and it makes it easier for your clients. And I think one thing that frustrated me the most as a practicing lawyer is not knowing how the judge is going to rule. Like not being able to prepare my client, not saying definitively how I'm going to rule, but just based on you practicing in front of me, listening to other people, what are those things that Judge Bailey is looking for? You know what I mean? I think that is extremely important in preparation for your client, because nothing was more frustrating to go in front of this judge and I didn't know what I was going to get because I can't set my client's expectations. It was just like, prepare for, Now people are. Oh, yeah. I don't think so yet. Maybe. Oh, yeah, that's right. We changed it. Oh, and that's something else I do need to mention. We changed the docket. So now the afternoon docket, instead of starting at 1:30, it starts at 1. We moved it up so we can hear more cases. And I, at some point, will incorporate at least 1 to 2 days out of the month where I start a docket at 8 a.m.
Not a morning person, sorry.
Well, if for those who are morning people, it just helps, especially if you all have to be in 2 to 3 counties within the same morning. You can get this one taken care of at 8, and you can still have time to make it to your other one at 9:30, depending on which county you have to drive to.
Yeah.
So, efficiency, convenience. Did anybody have any questions? Attorney Anderson, I see you're here for the 1 o'clock, right?
Yes, Your Honor, I am.
Okay. Well, thank you all for coming. I hope you got a lot out of this. There are snacks, refreshments over there for you. You're welcome. And if no one had any questions online, see it.